think people get mad at us because we don't say it every single time. But, you know,
Well,
we're telling you what the ATF is saying
well,
most of the
also,
time.
we as attorneys, we have to tell you when you are going to get arrested, whether or not we think it's just and right.
Yeah. We are the Armed Attorneys. Today we're talking about a new case that was granted certiorari to the United States Supreme Court. This comes out of the ATF getting mad. You know, they took their ball and went home when it came to 80% lowers, frames and receivers, that rule. But we're going to be talking about that, what the current state of the law is, and how their attempted rulemaking kind of backfired on them, and what we expect to come out of the Supreme Court. But before we begin, show your support for the Second Amendment by hitting that like button. And by way of review, this is a case out of the state of Texas. This was Vanderstock, and in connection to our final rule on frames and receivers. Now, by a way of a little bit of background, when people talk about frames and receivers, what are they talking about?
We're talking about ghost guns.
Yeah, 80% lowers, unfinished frames and
Ghost
receivers.
guns. No, that is the ridiculous term for it. We are talking about 80% lowers. We're talking about generally kits that you can buy without an FFL because they are not firearms, unserialized. You mill out your own firearm with your 80% lower in the long-standing tradition of manufacturing your own firearm that we have in this country, because this is America, Richard.
Yeah, this is America.
That's what we're talking about.
And what the ATF did, and this is a little bit different than what we have seen happen in other areas, but unlike bump stocks where they're saying, hey, you know, they just tag on some additional language, this is kind of similar to that. The ATF just kind of fabricated out of thin air their own definition for what was considered a firearm. So
today, the Department of Justice is announcing several steps that we will take to keep guns out of the hands of criminals and reduce the risk of gun violence. We will close a regulatory loophole that has contributed to the proliferation of so-called ghost guns.
Contrast a little bit with, you know, we've been talking about the Bipartisan Safer Communities Act and how those have changed the law and then they are changing the rule. This is just a whole cloth change of the rule, and left a lot of people kind of scratching their heads. So if you wanted to look it up, this is the August 24th, 2022 ATF Final Rule 2021 R-05F. And essentially what they did is they added to the definition of frames or receivers. I'm just going to read it to you. The term shall include a weapons part kit that is designed or may be readily completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. So they added to the definition of a firearm what constituted a firearm, these unfinished frames or receivers. And ultimately, and for the most part, this affected sellers and dealers and manufacturers of these kits. It didn't really affect buyers. You know, I talked to lots of buyers who said, hey, I have one of these kits. What can I do? But this required people who typically made these kits, they had to go to a gun store, they had to be serialized, they had to be, you know, undergo a background check instead of, you know, shipped directly to your house. We saw lots of lawsuits ensue. And what happened next?
What happened is an injunction was granted, and essentially with the idea that this exceeded the scope of ATF's authority. You can't just go in and legislate. You are rulemaking.
That's a nice refreshing wave over the comments section,
isn't it? Yeah. This is for all those rules aren't laws comments we get. That is
we agree.
We agree, and so does the Fifth Circuit, and so does this district in Texas.
We agree with y'all. I think people get mad at us because we don't say it every single time. But, you know, we're telling you what the ATF is saying.
Well, also, we as attorneys, we have to tell you when you are going to get arrested, whether or not we think it's just and right.
Yeah.
We will always tell you when you're going to get arrested and advise you as such. And that makes people mad, but that's just our jobs. So what we have is like this idea that the ATF is actually, instead of making rules that help interpret the law as passed by Congress, they have actually made their own law, which in fact conflicts with the Gun Control Act of 1968, which, bear in mind, serial numbers were not a thing before the Gun Control Act of 1968, right? All of our transfer rules were not a thing before then.
Yeah.
You assassinate enough high-profile individuals in the United States, you get a little bit more gun control, but before 1968, we just weren't there yet.
And from there, so we have the district court issuing this injunction, stopping that rule from going into effect. Merrick Garland appealed this to the Fifth Circuit Court of Appeals. They dismissed the appeal. They upheld the lower court's decision in issuing this injunction. And what is our latest development now?
Okay, well, very recently, the Supreme Court of the United States of America has accepted certiorari, meaning they will review the case and rule, which I don't know how my heart feels about that.
Yeah,
What's your gut say, Richard?
well,
We haven't even talked about this yet. I don't know, legitimately. What do you
when
think?
the district court does what we want them to do, and then the Supreme Court's like, all right, hold on a minute,
I know, it's scary, right?
that's probably not a good sign.
But maybe, she says, hoping against hope, maybe they are attempting to issue some sort of sweeping change to regulatory bodies' rulemaking authority. Like maybe this is going to actually turn the tides and rein in the ATF, because they're our biggest perpetrator, but any regulatory body in its rulemaking capacity. Maybe they took up certiorari to do the right thing.
Well, and the only thing that gives me maybe a glimmer of hope here is the Supreme Court, and I don't know if y'all are keeping track of it, they have over a dozen gun cases
A
pending
lot
with
of
them
gun
right
cases.
now, which is kind
Bonkers?
of, yeah, which is very unusual. I mean, we think about Heller, we think about McDonald, we think about New York State Rifle and Pistol Association v. Bruin. We have never had this many Second Amendment cases pending with the Supreme Court that I can remember. So this is very unusual.
Yeah, before Bruin, we had New York State Pistol and Rifle 1, which was, I don't know, 2020, maybe 2021, maybe. The Supreme Court just completely disregarded, mooted it, I believe. But even that was the first in recent memory. In recent memory, what was before New York State Pistol and Rifle 1 that the Supreme Court took up?
It's been a while.
It's been 20 McDonald?
years? Yeah.
Yeah. So it was not something that happened until recently. We've got a good makeup of the Supreme Court for gun cases right now, so maybe this is all a very good thing. I also think we've got a good Supreme Court for reining in regulatory authority. So let's hope.
Yeah, but I mean, we have Rahimi, we have
Don't
Cargill,
remind me about Rahimi.
We got a lot of stuff going on in the court, but we have briefs due June 2024. We're going to see lots of people file into this case. Everybody's going to weigh in and give their opinions on it. But if we have in the meantime one of these Chevron deference cases, think Loper Bright, think the bump stocks, they might wrap this opinion up or wrap those opinions up and apply them to these cases as well. So that's something we're going to be watching. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And tell us in the comments, is it a good thing or a bad thing the Supreme Court's taking this one up? Until next time, we're the arms attorneys.